Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-Excerpt attorney John Deaton commented on the rumors, saying a Gensler resignation. In a recent development, SDI District Judge Jed Rakoff handed a serious blow to the decision in the XRP case. The judge's judgment authorizes the SEC to continue with its action against Terraform Labs and creator Do Kwon, strongly rejecting the difference drawn in the Ripple litigation between public and institutional sale. The court's verdict in Terraform Labs' lawsuit was made public by John Reed Stark, who shared it on Twitter. Stark, a former SEC attorney in the Enforcement Division, announced Judge Rakoff's decision on Terraform Labs' move to dismiss the SEC's action against them. Remember that Terraform Labs and Do Kwon's attorneys had requested the court to dismiss the SEC's complaint. The attorneys referenced the Ripple decision to argue that the assets in issue are not securities within the scope of the SEC. However, the SEC responded by arguing against adopting Judge Annalisa Torres's reasoning in the Ripple case and expressing its intention to appeal the verdict. In his decision, Judge Rakoff refused Terraform Labs' move to dismiss the SEC action, claiming that the SEC's jurisdiction and a reasonable argument that the Anchor Protocol and Luna may have violated securities laws. In an impassioned remark, Judge Rakoff specifically disputed Judge Torres's judgment in the Ripple case, emphasizing his disagreement with the methodology employed in that judgment. He disputed the difference between public and institutional sales, which was explored in the Ripple case. According to him, the Howey test does not distinguish between consumers depending on the provenance of their coins, since all purchasers might fairly expect to benefit from the defendant's efforts. The judge's decision also called into question the Major Questions Doctrine, a Supreme Court decision that prohibits regulatory bodies from exceeding their jurisdiction. Some cryptocurrency defendants, notably Coinbase, have utilized the argument against the SEC. Judge Rakoff rejected this argument, finding that the Bitcoin business does not have the same vast economic and political significance as other regulated industries. To stress the gravity of this ruling, Stark said that Judge Jed Rakoff is considered as one of the most distinguished securities law jurists in the U.S. federal court system. The former SEC attorney also emphasized Rakoff's reputation for taking an unbiased approach. Ripple's L22, David Schwartz, voiced misgivings about the court's judgment, stating that it seemed to be based on the particular attributes of Terraform Labs' scheme rather than the generic characteristics of cryptocurrencies. Schwartz pointed out that the court's rejection of the Ripple case did not seem to be founded merely on a fundamental disagreement with its rationale. It is instead based on the factual distinctions between the two situations. He gave two interpretations of the court's decision. In one case, the court disagreed with the Ripple ruling because it applied additional factors not included in the Howey test. As a result, it suggests that the court may not apply or follow the Ripple rule in this instance. According to Schwartz, this is the worst-case scenario for Torres fans. The second reading is that the court rejected the idea that it should adopt the Ripple judgment in the Terraform Labs case because of idiosyncrasies in the Terraform Labs action, rather than because the Ripple decision directly implicates the Howey elements, despite the unique circumstances of the Ripple case, justified the difference between public and institutional transactions. The court considers that same factors may not be relevant in the Terraform Labs case. Schwartz emphasized that this would be the greatest argument for proponents of Torres' decision. John Deaton, an attorney who advocates for XRP, has claimed that the United States Securities and Exchange Commission's SEC recent actions against the cryptocurrency industry are motivated by a desire to protect corporate capitalism rather than investors. Deaton emphasized what he perceives as an assault against cryptocurrencies, citing the SEC's activities directed at Coinbase and Ripple as examples. He said in his speech that his talk covered a wide range of topics, including the SEC's approach to cryptocurrency regulation and its stance on retail investors in the Ripple case, as well as the accredited investor requirements. Deaton, on X, Twitter, shares his firm stance that the United States is not a real capitalist system, but rather functions inside the framework of corporate capitalism. He uses the current economic climate and other factors to back up his claim. I've been stating for years that we don't live in a truly capitalism society, and I stand by that statement. In the United States, we have corporate capitalism. Take a look at how the requirements for accredited investors treat the middle class differently from the working class. Take a look at the assault on cryptocurrencies and on Coinbase, which welcomes unvetted users. ETIPS, pets, Tojafis 30x30. A retweet from John E. Deaton. Our John E. Deaton known, July 29, 2023. According to Deaton, the SEC has a wrong set of priorities if it directs its limited resources towards Section 5 prosecutions and focuses on the secondary market on exchanges rather than fighting fraud inside the crypto industry. He warns that if this strategy is adopted, it might discourage innovation and slow down the burgeoning Bitcoin business. Deaton also draws attention to the SEC's stance against individual investors, serving as friends of the court in the Ripple case. Deaton's position implies a lack of willingness to take into account retail investors' perspectives, lending credence to the idea that the regulatory body regulator may put the needs of huge financial institutions ahead of those of small investors. Related, Ripple predicts a $10 billion savings for financial institutions using blockchain technology by 2030. Concerns regarding a double standard in crypto legislation are brought up by Deaton. He said the SEC is wrong for not talking to forward-thinking organizations like Coinbase. Sam Bankman-Fried, the former CEO of the defunct EFS exchange, met with SEC Chairman Gary Gensler many times. The regulatory body's efficacy and impartiality, as well as the regulating body and the broader framework for digital assets, are called into question by the uneven differential treatment. The Securities and Exchange Commission's SEC. Inconsistent treatment of different market participants may slow the development of disruptive startups while benefiting more established organizations. On July 13, 2022, Judge Annalisa Torres announced her long-awaited decision on the SEC's summary judgment proceedings against Ripple Labs. The 34-page judgment was a triumph for both the SEC and Ripple Labs, implying that certain sales of Ripple's XCoin constituted securities, but not others. Proponents of the cryptocurrency sector applauded the decision, which implies that the XRP tokens themselves are not securities. As regulatory pressure builds, this verdict seems to give important support for the young business. The SEC first filed this case against Ripple in December 2020, charging the company and two executives, Christian Larson, co-founder, executive chairman of its board, and former CSU, and Bradley Garlinghouse, the company's current COU, with securities law violations, alleging that the group raised more than $1.03 billion through unregistered securities offerings. While this is not the SEC's first complaint against a cryptocurrency startup, it is perhaps the most high-profile file. Ripple's XRP token was the third biggest token in terms of market capitalization at the time of the filing, behind only Bitcoin and Ethereum. Given Ripple's resources, the industry anticipated the business to fight hard. Special conditions. Ripple sold considerable amounts of the XRP token to these businesses and used the proceeds to improve the market for XRP and develop uses for XRP's ledger. Ripple went to tremendous lengths to advertise XRP, and the court identified many instances when the business seemed to link the token's price to the corporation's own efforts. Furthermore, the judge relied on terms in the sale agreements to back up her findings, noting that the buyers agreed to lock up provisions and implied that they could not have reasonably expected to be purchasing these tokens for use as currency or other consumptive use, Ripple suggested. Rather, the judge believed that these parties understood the sale of XRP as an investment in Ripple's efforts. The judge looked readily persuaded that the institutional sales satisfied all four prongs of the Howey test, that the sales formed an unregistered security, and that the sales constituted an unregistered security, and found in favor of the SEC's summary judgment request. Judge Torres, on the other side, found in favor of Ripple in the programmatic sales case. Ripple merely sold a part of its XRP holdings in simple bid-ask transactions across a number of exchanges for these sales. Ripple had no idea who the purchasers were, and the buyers had no idea they were buying tokens from Ripple. This information was crucial in the judge's decision. In contrast to the institutional buyers, who were aware that they were purchasing from Ripple and were ultimately investing in Ripple's future efforts, the programmatic buyers were unaware of who the seller was and so could not have been investing directly in Ripple's future endeavors. The judge reasoned that the purchasers may be purchasing the XRP coin for a variety of reasons unrelated to Ripple, including just buying based on general cryptocurrency market dynamics. According to the SEC's own filings, many programmatic buyers were entirely unaware of Ripple's existence. Given the divide, Judge Torres' order implies that the XRP coin is not a security. Following the verdict, the majority of the main cryptocurrency exchanges reintroduced the token for trade on their systems.